recommend having the IP ownership agreement with the employees. Now, I split these next few slides up between employees and contractors, independent contractors. There's different standards that apply. In this slide, I'm talking about the common law. Common law was just in court law made, and there's general principles in common law here that I set out for employees. And generally, courts have said in the U.S. legal cases going all the way up to the U.S. Supreme Court have said that whoever invents, and this is the default I think most companies should just put in their mind when they're dealing with this issue, and this is the way investors are going to approach the issue, is whoever invents or writes a material or comes up with something owns that. So if I think of an idea, it's mine as long as I have possession of that. If I came up with the idea, it's mine. And the U.S. intellectual property system is built on this doctrine that whoever invents it owns it. And what companies now are doing, and courts have said, companies can contractually get around this common law doctrine that whoever invented it owns it, and people can start assigning their rights to companies. And but it's the exception to the general rule. So now the common law has also recognized this hire to invent doctrine, and that's basically saying if the employer hires someone to design or come up with the product, the invention belongs to the employer, even if the employee comes up with a new or novel idea on how the invention might be built or better designed or produced. So if you're hired to invent, work for hire, then the employer generally owns that. But it's this common law doctrine and it gets a little gray if you start getting into that doctrine and have to rely on that doctrine. And that's where these IP ownership agreements will come into play. And you can clearly spell out to the employees and the contractors of who owns the intellectual property under what circumstances to protect the company. Now, you hear about shop rights sometimes as well. And again, this is a common law doctrine that if the employee has come up with an invention, but used business time and materials to invent, but it was unrelated to why the employee was hired, the employer would have this shop right to basically a license, a royalty-free license to use the invention. But if the employers or the companies going back to these common law doctrines, it's going to be a little gray, and it's tough to rely on those to establish ownership over the intellectual property. So the law here in California in the US has said the employees can assign their intellectual property to companies, and this can be modified by contract. So that's where most companies, they need to look at this and have these invention agreements and trade secret agreements in place with the employees so that it clearly spells out who owns the inventions and how that's going to be dealt with under these different scenarios that come up. So the agreements are detailed. I've got some examples. I haven't shared those with this because I was a little nervous. I want to walk you through some examples. If anybody wants an example, reach out to me and I'll walk you through that and tell you about some different issues that come up in the agreements. But companies need to have these in place. Investors are going to be looking to the company to make sure that these are in place as well, so that there's a clear chain of ownership of those ideas. And if you don't have these agreements in place with the founders, with employees that come on board, it's going to raise a lot of red flags with the investors, because the investors might say, well, if we have to go back to common law doctrine and try to prove ownership, it's not going to be worth it. And there's a lot of gray areas. So these agreements are going to be key for investors. Now, under California law, the contractual assignments, I've got these statutory restrictions set out here. Under California law, an employer cannot require an employee to assign rights to inventions that are unrelated to employment. So these are, for example, inventions that the employee develops entirely on their own time without using company equipment, supplies, facilities, or trade secret information. And it's also important to note that to the extent an employment agreement violates this prohibition under California law, the agreement is void and unenforceable. So employers need to be careful that it doesn't overreach as well. The contractual assignment doesn't overreach. It could void the entire agreement. So be careful about what language you have in these agreements. Have a lawyer take a look at them. And again, to the last bullet point, the courts, California courts and the statutes don't like when companies try to have an employee say that basically after they leave employment, whatever they come up with for inventions after they leave employment, that's going to be the intellectual property of the company. Courts and California statute looks down on those types of agreements. They're very tough to enforce and generally unenforceable under California law.